Oh, I was looking in this glossary, yeah, and they have what's called stare decisis, a Latin phrase meaning to stand by decided matters. It refers to the judicial policy of following legal principles established by precedents by previous court decisions. Last night I was talking about how a protection order is really a lawsuit. And when you issue a protection order where the petitioner doesn't sign it and I wasn't given actual notice and opportunity to be heard, yes, it sets a certain amount of precedence. Now I know there's a case number on this court hearing, and the case number is 112006711. But let's say that Clallam County in Washington State and every state is allowed for a protection order where the signature of the respondent is not there, where there's forgeries, yes, and where the respondent did not receive actual notice of the hearing. Respondent was or was not present at the hearing. And they said, well, you're going to have to motion the court. And I said, no, I don't. So you didn't follow the court rules. You didn't do what the instructions say. You violated the VAWA. You violated the Domestic Violence Protection Act. You did this for 6 years, and any person that's in any court, any prosecuting attorney, could use this as precedence. As I understand it, it's an actual court case. Now let's say every commissioner and every judge in America decided that they didn't need the signature of the petitioner. They don't actually have to give actual notice and opportunity to be heard to the respondent. In actuality, the law requires the order to say if the respondent received notice of the hearing. Now you would have thought, since I've sent so many emails, that I'd made mention, well, you could obstruct the rights of every parent to have their children. You could obstruct the gun rights of every American citizen. But what if somebody actually used this case as justification to arrest somebody else? What if there's another county commissioner in another court in another county that decides, well, I don't need the petitioner to sign it and I don't need to serve the respondent? What if they decided that every judge in every county is going to allow for this to happen because they all can say, I don't need the petitioner to petition the court, and I don't need actual notice and opportunity to be heard to be given to the respondent, nor do I need proof of service or any personal service. Now, it seems to me that every court in every county in every state has that one right, that they can take over the personal lives of every American that motions the court or doesn't motion the court, but let's say you did, you just didn't want to sign it. That motions the court that as soon as you issue a protection order that violated my constitutional rights in 2011, you set precedents that every judge in America can use this as justification for issuing a protection order without a petitioner or a respondent. Now, when you did this, this is an actual court case. Now, there have been those that have said, well, you're going to have to motion the court, and I'm like, no, you violated my constitutional right to due process. Well, you're going to have to take it up with the judge. Well, the judge issued a protection order where there was not actual notice and opportunity to be heard, and they violated my rights approximately 16 times before court hearings and 9 times after, inclusive of, this is a court case number 11-2-00671-1. Now, I have the state's response here. Now, they would say in a little county in the middle of nowhere, in the farthest reaches of the west coast of the United States, the state gave their reason. Furthermore, City of Auburn versus Solomon states the intent of domestic violence is to protect the victim of domestic violence. Now, I don't know if they issued the protection order according to the law or not. I don't think they really researched it in the prosecuting attorney's office. But, as they said, the defendant has had significant time to seek a remedy in regards to the order for protection. Section 9 of the order specifically allows the defendant to seek a review of the motion at any time in the Clallam County Court Superior Court. Now, when I think about precedents, the issuance of this protection order and the refusal to remove it has opened the door that every judge in every county can issue a protection order that doesn't require the signature of a petitioner, and the respondent doesn't have to get actual notice and opportunity to be heard. Now, I know I've had significant time to seek a remedy, but my remedy was to inform law enforcement that my rights are being violated and that my sons are missing and kidnapped. Now, since this county's court system has to issue protection orders according to the guidelines of the Violence Against Women's Act, and I just sent, 180 new email addresses, approximate number, to those that are homeless representatives, legal clinics, and those that would say, well, it doesn't really matter. Unless, of course, I sent hundreds of thousands of copies of RI.PDF, and if it is such that there's a judge sitting on a bench in some county court someplace in America says, well, I'm going to do the same thing as the county commissioner in Clallam County. I'm just going to start issuing protection orders without the petitioner signing them and without the respondent being given actual notice opportunity. Now, let's say I've mentioned that I'm going to sue every judge in America that refused to enforce their promise of supporting and defending the Constitution of America. And they all thought, well, it's not my jurisdiction, but you can use this case as precedence. Oh my gosh!